Hi, and welcome everyone to the webinar for Centuro Global. My name is Asma Bashir, and I'm a co-founder at Centuro Global. Just to give you a little bit of background about Centuro Global, we advise companies on all types of legal issues, from complex immigration law to managing risk and compliance, and also providing any strategic advice to mitigate risk. So I'd like to thank you all for taking the time to join us for this webinar. What I hope is going to be very informative and also interesting for you, because it's packed with so much information. Even up until this morning, I can tell you the changes to the immigration rules keep coming in. This webinar, this topic actually has been so popular with people. We've had more than 200 people sign up for it. So it just goes to show the importance of the subject matter and how it's impacting companies everywhere. So basically, what I'd like to do is just give it another minute before we kick off the presentation. But I also want to just say I've just come off a conference with the Home Office Minister this morning. I was hoping that he was going to give us some insights and clarity on the changes that are going to occur. But sadly, maybe I was too over ambitious about it, but he didn't quite meet the expectation that we had. But albeit, I will say that one clarity I did get, perhaps not from the minister, but from the Home Office directly this morning, is that there are some significant changes coming up on the 2nd of April with regard to defined cause applications. So I'll go through those at the end of my presentation. So let me begin first, and I think we've pretty much got a sufficient number to get started. So today I'm going to cover a wide range of areas. For the purposes of this webinar, we're going to focus more on employer-based applications rather than care workers and health workers. So we will kick off with what the recent changes are. I will touch on what the 5-tier plan is, and then we will talk about why are these changes happening, why now, and the challenges these rules create for you as businesses, and then what your company can do to prepare. So let's kick off with the introduction. So as you know, what I would like to say to you is, if you would like to ask any questions, we do have a Q&A section. If you could please put your questions in there as you go along, and at the end of the webinar, I will try and answer them as best as I can. So as many of you all know, there's been so much press attention with this. On the 4th of December, the government announced its 5-point plan. Now, the last time I saw such significant changes happen to the immigration system were when the points-based system came in 2008. And since then, we've had lots of different changes, rules coming and going. We've had quotas. We've had the tier 2 system changed to skilled worker. But recently, the number of changes and the pace at which the changes are happening is quite significant, because we've not seen this pace before. And normally what the government has done is gone through a consultative process, right? So they would engage with companies, they would engage with people who are impacted, and they would actually ask and go through a consultation process and get opinions and then make their decision. But this has been a really fast-track pace at changing the rules like we've never seen before. So the 5-point plan, for those who are not aware of it, it's very simple. They want to reform the health and care visa system and the dependents, increase salary for skilled workers. As we all know, there's an end to the salary discount for shortage occupation roles, and I'll talk a bit more about that, and then increased income for family applications, and then the review of the graduate route. So in the past, again, for those who may not know the past, we used to have the post-study worker route. It was there and then it was gone. So now we've had the graduate route, and it remains to be seen whether it will remain or it will go, or they will actually just refresh it, maybe change the salary bandings or have further criteria around that. But there is more to come on the graduate route, because the Migration Advisory Committee has been commissioned yet again to reach an outcome on that by the 14th of May this year. So that's another significant change, which we only found out about on Monday. Again, it goes to show the pace of the changes that are happening. So the initial announcement was followed by a fact sheet, which again, we can send a copy to you if anybody who would like to see one. It was released on the 21st of December. It has all the details of the policy changes and the impact. And it's estimated that these reforms are going to reduce net migration by 300,000 this year. Now, call me cynical, but I actually beg to differ in terms of, are these reforms really going to reduce net migration? Now, what the government's figures talk about is increased migration, but remember, we've had COVID. So the healthcare system has had to change. We've had to bring more care workers into the UK to scale up the NHS. That has increased numbers significantly by 153%. We've had COVID. So there's been temporary relaxation of the rules where we've had people coming in during the last 3 years. We've had Ukraine. We've had that policy. So these numbers factor into it. We had Hong Kong and BNO passport holders. That also factors into this. So those numbers are skewed to say that net migration has increased, because when you look at the YouGov polls and you look at any of the statistics, basically anyone who's looked at or really investigated the skilled worker routes or the graduate routes, the findings are that they are at the right levels. They're not either increasing or decreasing, but they're at a basic level. So I think there's a lot to be said for whether we have increased net migration and whether we're looking at the wrong statistics. I don't know, but that remains to be seen. But that's just my view. So there are a number of changes to come into force as of 4th of April, and we'll go into those and explain those a little bit further. So what are the key changes for employers? A new band of 38,700 as a general salary threshold is now being set. So again, this is a huge increase from the 26,000 that is on the list at the moment. And what we're seeing with companies at the moment is a lot of companies are saying that this is, it's a much higher rate of pay, particularly for graduate roles or particularly for people who are at, say, a couple of years qualified. And even this morning, when I was listening to the minister and I was listening to his Home Office representative doing a presentation, and we raised this question around the salary thresholds, particularly for shortage occupations like engineers, as an example. And his response to that was, well, yes, I know the going rate for engineers, as an example, or tech workers is between 32,000 and 38,000. We're still reviewing that. A consultation will happen. So I didn't get a definitive answer from him, but the 38,000 mark is quite high for what we have. But then we are here. There will be a consultation in terms of roles, positions, where companies feel that actually they can't achieve these salary levels or they can't get the talent that they want to bring to the UK, and their company has an impact as a result of that. And so anyone who feels that way, anyone who can present evidence, anyone who feels that there is a strong business case, I would strongly recommend to get in touch so that we can get involved with the Migration Advisory Committee, because we're collecting data and information on what businesses' views are and what you're thinking about in terms of these changes. So it'd be really interesting to know how you feel about it. Now, although the 38,700 is the set new threshold, we also need to look at something which is called eligible occupations, right? So there are eligible occupations. So for example, if you have somebody, if you have somebody that's, say, a skilled person, a senior director, a VP, a senior person that's coming into your organization, not only are you looking at the threshold, but you now need to look at the salaries that you would have normally paid. So if you gave a senior manager, say, a salary of, say, 50,000 as an example, hypothetically, you would now be looking at paying them 80,000 according to the median level that's been set by the Home Office. So this is according to the national, the ONS office and stats. And again, this is still being researched and commissioned and investigated, but they have gone fast track into introducing these changes by the 4th of April because they feel that this is the right way to go about it. So although this will become what the rules say, it doesn't mean that things can't change with enough companies coming forward and providing evidence and information to say how it's affecting you on a day-to-day basis, how it's affecting you in terms of hiring talent, and therefore, there are ways that we can do this. I mean, the last time this happened with the points-based system, I can safely say to you, we had companies coming in and saying it's impossible. They've got rid of the resident labour market test, they've got rid of us bringing in projects into the UK, we collaborate with big businesses outside of the country. We can't now sponsor people who are not, unless they're employees. Then there were business visitor issues, and companies were saying we can't manage the way that the rules are designed. So we actually got involved. We created stakeholder groups. We went to the Home Office policy team. We actually presented them with a business case. And I think I say that the Home Office it's not a witch hunt. They are people at the end of it. If you give them a good enough argument, they will make exceptions to the rule, they will try and listen, and they will engage. So I would encourage everyone that is affected by this to consider engagement and collecting information and data, because as a significant group of people, you have more impact than if it's one or two. So that's what I would encourage people to do. So I think this change in percentile, so right now, as the rules stand, you would look at a 25th percentile. So if a salary, if you look at the line of, from 50,000 to 150,000, you would look at the 25th person who's on that salary, and that's what they would measure it against as being the reasonable salary. But now they're going to go to the 50th percent. So people need to be aware, or companies need to be aware, that when you are offering skilled worker roles for positions, which the Home Office will then assess, there is a possibility that applications will get declined. So that's, I think, quite significant, because again, I've had feedback from a lot of clients saying that changes a lot. Not only are we dealing with the minimum salary threshold, but we're now also having to deal with increasing salaries for certain people. So does that actually make it harder for people to attract the right candidates to the UK? Again, it remains to be seen once these changes take effect. So this here is so the shortage occupation, actually I should say, has been replaced. So I don't know how many companies are familiar with the shortage occupation list, but the UK has a shortage occupation list, and if anyone is on that shortage occupation list, it means that you have a reduction in the salary that you would offer on a normal standard basis, because the UK doesn't have the right talent. That shortage occupation has been replaced by the immigration salary list, and it has been reduced to only 21 occupations. We will share this information with you afterwards, because it's very small to read here, and I don't expect everyone to look at every single title here. But I can safely say that the majority of the tech sector, engineering sector, has all been removed. So those categories will no longer be part of the shortage occupation list, and it's been replaced by things like fisheries, carpentry, construction. And those are the ones that are regarded as the shortage for the purposes of this exercise. However, what I'm going to say again is this has, again, the MAC, the Migration Advisory Committee, was commissioned to basically make a decision on this, reduce the shortage occupation list as fast as possible. They announced this on Monday, right? So it's only been a day or two. I haven't had a chance to go through it in a lot of detail. But now they've been commissioned, that the dates haven't come forward yet, but companies, they will actually invite companies to give evidence on whether tech roles, the energy sector, for example, oil and gas companies, engineering roles, process engineers, you're looking at production engineers, chemical engineers, structural engineers, they're all removed. Do we have them in the UK? I mean, I would beg to differ. So if they're no longer shortage and the government doesn't recognize them as a shortage, what is UK business going to do? So we will share this list with you afterwards, but this is what it's been reduced to now. And if you feel strongly about it, we would recommend that you actually get involved with the consultation when the dates are announced. So what other key changes do we have for employers? I mean, those were the significant ones that in fact impact you if you have a sponsor license and you're obviously bringing people to the UK on a regular basis. There will be a new IT system coming up soon. No date set, but it's imminent. And this new IT system will be within your license. The sponsor management system will have a process where you will have a navigation bar which says sponsor a visa. This will allow you to allow your employees to then make an application. So right now, we apply for a COS, we pay for a COS, the COS is approved, and then there's a separate process to go and apply for the visa. Going forward, you will be able to sponsor a visa through the sponsor license. So this is all underway. Then, in terms of managing the license, you will be able to carry out all your reporting functions on the platform through the SMS, and you will also be able to take action on any obligations that you're required to do. And I have to say that there is a reason behind this. The new IT system will sound more efficient, it will be easier to navigate, and there's more that will be controlled within it. But with greater access and greater facilities comes greater control. So with that, the Home Office will have expectations that every company manages compliance far more robustly than maybe you've seen in previous years. Now, in my experience, I've not seen that many compliance audits happen over the last 3 or 4 years, probably before COVID, even prior, maybe a few years before that as well. When the points-based system first came in, there was an abundance of compliance visits. We were attending compliance visits practically a few a week at the time. They would turn up, officers would turn up at premises and so forth. Again, I'll go into audits in a little while, but really the point of me talking about the IT system is if once this system changes, it will change overnight, and the next time you log into your system, it will show a very different navigation bar, very different facilities. So it's all about getting familiar with it, understanding it, what does it mean for you? And it's not just, oh, it's great system, right? It's made it easier for us, or it looks great. But please remember, behind the scenes, there is an obligation for you to manage this properly. Everything you record, everything you do is going to be with the Home Office. Right, so then we have already seen replacement of physical immigration documents with e-visas for new applicants. Anyone who already has a biometric card or a physical visa in their passport, we're actually going to see the end of that by the end of this year. So how will this work? Applicants are going to be required to register a UKVI account. So they will be able to access their e-visa version of their existing permission online. And this will be like you use a view and approve service. So to demonstrate to an employer, you would view it, you would use the online system, and employers would then use that rather than a physical document to authorize or verify that they've undertaken a right to work check. Details, however, of this registration process are still yet to be released, although it's working with new applicants. But for existing applicants, we're still waiting for the Home Office to deliver an impact and timing. We hope it will be soon, but there's no date set. But it's coming, and that's the reason why people aren't renewing their biometric cards, because it's coming to an end, and there will no longer be a physical document for them to show to an employer. Then we have the electronic travel authorization for visitors. So this is basically quite an interesting one. So this is the government's plan for digitization of everything, digital permission to travel scheme. And at the moment, they have released it to 5, or I think actually it's maybe more, the Middle Eastern countries like Qatar, Bahrain, Jordan, Kuwait, Saudi, UAE, Oman, I think. So those countries previously required a visa before they travel to the UK. So they had to have a physical visa in their passport, then come to the UK. But what the government has done is allowed electronic visa system to work, so nationals of those countries can now come without a visa. And that is as of effect of, I think it's the last week of February 2024. So they are already able to do that. However, going forward, people like the US nationals, Australian nationals, what the government has done is brought it in line with European nationals. And now every single person that comes to the UK who is a non-visa national will need to apply for the ETA. So electronic travel authorization. So it's almost similar to an ESTA. So if you're going to the US, we apply for an ESTA. Now everyone who comes to the UK that didn't previously need a visa, could just turn up at the airport and present their passport, will need to have an ETA in their passport. So that's a change that's occurring. And I believe this is going to be rolled out very soon. Again, no imminent date. I believe there's a £10 fee payment, again, a reason to collect more fees, and processing can take up to 3 days. So this could have an impact on high volume business visitors to the UK, or when you do short notice travel and people just get on a flight and they want to travel. Americans, particularly Japanese nationals, Singaporeans, they've been pretty much used to a very easy ride. You know, you're in one country, travel to the UK. Now it could take up to 3 days to get your ETA approved, and you will not be able to come to the UK without it. So then we've had liberalisation of the visitor visa. I say liberalisation, but I'm not sure. So again, I have been used to business visitor rules over a number of years and changes to it. And historically, I mean, business visitors has been a real grey area. I'm not sure what this change does, although what the Home Office has said is that it's allowing people to come to the UK to work remotely, but not to be employed in the UK to work remotely, but as part of their overseas role if they need to be here. More so for ICT workers, I would say. And they expect the remote work to be no more than a month, although a visitor visa is permitted for up to 6 months. So how do you police something like that? It's unknown and it's very difficult to say. So people coming on a business visitor, I would still say it's unclear. I mean, there's probably going to be more guidance, more definition around it. But this one is going to be difficult to police. So I think companies will have question marks around. I mean, I would have question marks around this, that if you've got a number of business visitors coming in and you are then hosting them in your premises and they are staying there. So you could have a project that you're doing. And I know this applies to the energy sector. So sometimes they're in projects and you've got 50 people coming into the UK at once. And they could be working remotely on behalf of their employer overseas, but at the same time, they're contracted to the company in the UK. So when does that become work? And when does that become a visitor? And when does that become remote work? So there are challenges around that. And I think it's really important to seek advice and get clarity, because I go back to this issue of, control in terms of reporting obligations, putting the responsibility on employers and sponsors to be more vigilant on how they do the reporting and how they handle compliance going forward. So it might seem like an easy option. Oh yes, this has allowed us to do a lot more, but actually there's going to be a lot more responsibility that comes with it. Okay, so next, obviously we've seen the increase to the health surcharge, which is self-explanatory. That's already taken place. And the increase in civil penalties. Goodness, that I think is, I'm going to talk about that a little bit later, I think, in illegal working. I mean, we've all seen tripling of the figures for illegal working. And part of what I've just explained there is that they're putting more emphasis and responsibility on employers to manage compliance. And the other change that we all know is sponsor licenses no longer need to be extended, and you get a 10-year automatic renewal. So again, this is widely already reported, and companies who are not aware, if your license is about to expire before the 6th of April, you must renew it. You have to click the button and you have to say that you wish to renew. If it expires after the 6th of April, you need to do nothing, and it will be an automatic extension. And it's very important to understand that, because if it expires on the 5th of April, then you could stand the risk of losing your license. So other changes to consider. The MAC is carrying out a review of the graduate route, and they have to present their findings by the 14th of May. And you can see how quickly this government is trying to put these systems in place. We had an announcement on the 4th of December. Then the fact sheet came out on the 21st of December. Then we've got all the changes that happened in January, then everything that's happened in February, and then the shortage occupation list being removed. We've seen the salary increases. Now we're looking at the graduate route, and the MAC has been set. I mean, previously the MAC used to take months to do this. Now they're saying the MAC has to come to a conclusion by the 14th of May. So it's really important that if anyone has any views, any thoughts, this is going to impact your graduate programs, it's going to affect you in any way, to speak up, because unless you present evidence or details or business case or representations about what it is that is going to impact your business, then obviously there's no one who can listen to that or understand that to make sure that that these points are put across before any changes happen. And then the next change, again, these are all happening in the last few days, right? So I've got a kind of a list of so many changes that I'm struggling to keep up with it myself. Unmarried partner requirement. As we all know historically, unmarried partners were required to show cohabitation of living together for 2 years historically. As of yesterday, unmarried partners no longer need to be cohabiting for 2 years. You just need to prove that you're in a relationship. So I guess the world of remote work has now demonstrated that maybe we can have remote relationships too. Excuse me, my eye is very watery, so excuse me if I just dab it there. And so that's an interesting one, because for years we had spent time trying to find documents that would demonstrate that couples were living together, and now suddenly that's no longer the case. So that's a welcome change. Undefined cause delays, right? Now, I don't know if any company is experiencing this, but lots and lots of reports on undefined applications that are on hold for since last 3 months. So since December, if you made an application to apply for a cause, possibly because of the change in the salary thresholds, and you haven't had a decision yet, then let me tell you something. Today, I found out, well, it wasn't from the minister himself, but it was from the Home Office directly. It's been updated that on the 2nd of April at 7 p.m., the Home Office is going to turn off its sponsor license system, and they're going to turn everything off. And they are going to try and get through as many defined cause applications as they can by that time. That's a few weeks, right? So take from that what you think when they say that they will try and decide as many as they can. It probably means that they will decide the ones they feel they want to decide. But by the time they open up again, so from the 7 p.m. on the 2nd of April to the 9 a.m. on the 4th of April, there will be a shutdown. And on 9 a.m. on the 4th of April, they will reopen the system. And that is when every application that you made prior to that date will be cancelled. So if you don't get an approval by 7 p.m. on the 2nd of April, basically that's it. Your applications will be cancelled, even if you submitted the applications prior to that date for defined cause. Under the current rules, you will no longer be able to rely on the approvals for that. You will have to resubmit from the 4th of April with the new salary threshold. The other point to bear in mind, which is extremely important to understand, is if your application does fortunately get approved by the 2nd of April, you have to use your cause by the same date. And you have to use your cause, and the person has to make the application and submit it for a decision before the 4th of April. If you use the cause and they submit the application after the 4th of April, the new rules apply. It's really important and it's really critical that you understand that any concerns around that or any issues around that, you could lose an applicant, or you could lose the application and you have to start all over again. So this is a strange, but anyway, an update I've had today. So I thought it was really important to share it in this group. And it's just, the updates just keep coming in. So as I said previously, I think there's going to be a further review of the immigration salary list, which is now no longer the shortage occupation list. And I'm used to clients in the energy sector, in the tech sector, and tech roles, software engineers, right? So many developers, programmers, they've been taken off the shortage occupation list. And so there will be a review. I would encourage employers, anyone in this audience or anyone who feels strongly about this, to participate and let us know how you feel and what you feel about it, so we can present some data and get involved with the consultation when it takes place. Stakeholder engagement, I say, is extremely valuable, because without having a voice and without presenting what it is and how you feel, and with evidence, and telling the Home Office or the government how this impacts you and how it impacts the country as a whole. Because if you think about it, if we're not producing tech talent, or we're not producing engineers, and I know, having looked at data and research in the past, is our own graduates, even if they qualify or come out of universities like Imperial, Oxford, Cambridge with degrees in engineering, they go into investment banking. They don't want to do roles because it pays far better. So if we can't look at homegrown talent, where do we get our talent from? And so it's really important that if you have these issues, or you feel this is going to impact you, please get in touch, and we can obviously try and incorporate that into the stakeholder engagement. Okay, so why are these changes happening? So I think I did touch on this earlier. These policies appear to be reactionary response to what the government says is high net migration. But as I've said to you, I'm a little bit dubious about it, because I feel like the figures are skewed. We've had Hong Kong, we've had Ukraine, we've had COVID, we've had Brexit. So even Brexit, right? Because before, the European figures were not being counted, and perhaps now they are. And so that's what's led to the increase in net migration. And it isn't necessarily the people that are from the skilled worker side or from the graduate schemes. These are completely different categories. Also, we've seen that there is a general election due this year. So it could be that the government is really trying to rapidly change their stance on immigration and bring in more voters. And also the health and care worker system. I mean, we know that our NHS and our healthcare worker system is pretty much at its low. We've had to look outside. We've had to bring in numerous health workers from outside of the UK, and that has really increased by 153%. So that is where the increase has been the most, and it's contributing to the net migration figures. So here is a timeline of changes. Again, I'll send this out because it's very difficult to read here, but it will tell you some things that have already come into force, other things which are coming into force, and we'll go into those. So what are the challenges for employers, in terms of what's happening? To be honest, as I said, with greater control, over your decisions of who you decide to bring into the UK comes responsibility to be compliant. And the civil penalties increasing from 20 to 60,000 is a direct result of just that. So the Home Office is expecting companies to internally have better record keeping, to maintain their licenses, right, and look after and keep a log of everything that you're doing. There is the employers will be able to rely on a statutory excuse against liability for illegal working. But this is if you carry out the right to work checks in the way that the Home Office has provided guidance for. So it's not about how you believe that you have carried out the checks, you have to follow Home Office guidance. We will go into a lot about auditing and about internal audits. We're doing a masterclass on this next week, so I'll share more insights. We'll be going through an entire process on how to do an internal audit and ensure you've got your systems and processes up to speed. So the starting point for a first breach, so if you've never been non-compliant and you feel that, so the Home Office feels that you have actually committed a breach, the first fine has gone up from 15,000 to 45. Now, a lot of companies say to me, oh, yes, we're up to speed and we have everything under control. We've got very good systems. Our recruitment systems are fantastic. Our record keeping is great. Our personnel files are wonderful. However, the number of companies I have seen, and I'm talking about large multinationals, not just small companies, that actually fall foul of these rules is unbelievable. And it's really important that you put those systems and measures in place. Now, a simple thing I can tell you, I had a client where he was a senior in his organization, and he had given his PA instructions to go ahead and extend his visa. So he had obviously gone out and I think he was a frequent traveler, so he had 2 passports. He had asked his PA to consider the extension. She had obviously instructed somebody to do the extension. Somewhere along the line, she had an issue with a relative having passed because of COVID, so she had to leave and somebody else replaced. Whatever the reasons were internally, the visa never got extended. It was 2 weeks after the expiry that he realized the visa had expired. The visa was never extended. A panic situation in the entire organization. But a situation like that, let's say if it wasn't detected, or if it wasn't picked up, or somebody didn't realize it had happened, if the Home Office picked that up, that is a serious breach. And that is something, if it's a first breach, would result in the penalty. And if it's more than one breach where maybe your systems weren't robust enough, the Home Office would decide on the level of penalty that they would actually exercise on that. So 2024, as you can see, the pace of the changes that have happened to the rules is all about audits and compliance visits. And that's really the mandate the Home Office is putting forward. So they are saying that we've not gone out to visit. We've gone quiet over the last few years, understandably. Now that we're putting our systems in place, we're going to get tougher on employers, and we're going to get tougher on compliance. So more officers have been sourced to go out to meet with the employers, to review their processes and systems. And in the past, what I've said is I've done so many audits. This is something that is pretty much, I guess, how would I say it? Most clients say to me, and if an officer turns up at your premises and says, I'm here to do an audit, that's all fine. I think you would talk to them politely. But if the person that is responsible for your record keeping, or for your migrant workers, or who has the information isn't available, or they're not there for the day, it is perfectly reasonable for you to say to the immigration officer that we aren't available today because we don't have access to the systems. Again, there's data protection rights. There's all kinds of legal reasons why you wouldn't be able to access that information. You can ask or agree a time with them and say, please write into us and we will agree a date and time. And at that stage, you can either bring in your immigration advisor with you or your legal representative, or you can actually get the right team in to be able to undertake the audit with the Home Office. The concern I have around that is if you're not familiar with the questions that are asked, you can actually get yourself into a bit of an entanglement. And I don't know if people have been through an HMRC audit, but it's quite similar to that, where they ask questions, and if you're giving answers which generally you're unsure about, it can be misinterpreted or misconstrued. And it's really important that you understand the consequences and the implications, and therefore undertaking this particular exercise with the Home Office is really important for you. So that's the current challenges I think you will face. And again, as I said, we will go into more about auditing next week. So what can you do to prepare? I think you've got to understand the consequences of these penalties and what 2024 was about from the Home Office mandate. So if the mandate is to come out and meet with employers and see, and this will probably, it doesn't necessarily mean that you have to have a high volume of migrant workers. Even if you employ a couple of people, right, you're still at risk of immigration officers turning up at the door and asking to do an audit, because from 1 to 1,000, it makes no difference. Excuse me. So then the question comes, what is considered an illegal worker? It can be anything. So it's not a straightforward definition that an illegal worker is someone who came to the UK under illegal claims that they didn't have the right visa, etc. That's not the case. If you are in an organization and a simple situation occurs where you've got a dependent of somebody that works for you, and maybe their relationship broke down and they're divorced and the employee didn't inform you, and when they undertake an audit and they discover that this person's spouse had reported them that they were no longer in the UK, or that their relationship had broken down, but this person continued to work, that's a breach. If you have a student that is working more than 20 hours a week, or is working in breach of their conditions of what they have, that is also a breach. So there could be, or if you've got somebody working who has a visa in one category but is working is working for you but needed permission to work for you, that is also a breach. So there could be all kinds of different definitions for an illegal worker. And my advice would be to understand the different nuances that there exist and what could constitute an illegal worker in your organization. Because if you've got an EU worker, if they haven't applied under the accession states and they didn't get their EU residence card and they can't prove it, that's still an illegal worker. So it could be that you may need to do an audit across the board. And again, clients often say to me, when you tell us to do audits across the board, we have to do them, to avoid discrimination and race discrimination and all the rest of it. You have to do an audit across the board of all employees, not just your migrant workers. And that means, to be fair and have fair practices, you have to ask everybody to produce passports or details of their right to work in the UK. And again, we'll go into more details about that next week. So in order to establish a statutory excuse, I think these are the steps that will make it important. The record keeping that you have will make it more important. And so you will have robust systems in place to be able to respond to it. So this code for illegal working came into force on the 13th of February. Anyone employed from that date is subject to this. So if you didn't carry out the right to work checks, then this is where a breach could occur. So we will talk more about this code of practice next week and what it means for employers and how you can ensure that you're going to remain compliant. The other piece of advice that I would definitely give is to undertake regular internal audits. So it's not just about having one-off audit and then basically that's it. I think you need to try and do as many as you possibly can. Internal staff training, please try and do as much as you can there, because I think it's important that your staff understand what the implications are. Create better policies. Again, if you need assistance with policies, seek advice and seek specialist guidance on any irregular situations that you discover during your internal audits. I think it's always good just to clean up internally before you think anything happens and be prepared. So next week is our masterclass on preventing illegal working. We will go through what an audit could look like, what Home Office officers would come in and ask you, how you would report any illegal working that you found, what do you need to do, how do you maintain your record. So if anyone wishes to attend that, please do register, and we very much look forward to having you there. But for now, I hope you found the session informative. If you have any questions, please do let me know. I'd love to answer them. But yeah, thank you so much for joining, and look forward to seeing you again at future events. Okay, right. I've just been given some questions now. So I've got here, Karen Colley. Will the new e-visa replace the imposter check that is required to overseas candidates who previously provided a passport, entry clearance, BRP card as their right to work check? Will this e-visa replace all that and be sufficient for right to work? This e-visa will replace that. That is what the Home Office has said, but the guidance will be issued when the date is defined that is the case. So right now, nothing is definitive, but that's what the mandate is, and that's what I heard this morning, that this e-visa system will become the right to work. So that's the proof and the evidence on the online system. Okay, question 2. I'm going to try and get through these very, very quickly. Ashwani Kumar, I have a question regarding the skilled worker visa. If someone was on a skilled worker visa and then moved out of the UK to work within the same company in another country, would they be allowed to come back to the UK if the existing employer or a new employer is ready to sponsor them, or would they be deemed to have abandoned their skilled worker? Right. Unusual question. If you are a skilled worker and you go out of the UK and you are working with the same employer, you are allowed to have you can report to the Home Office to say you're on assignment if it's with the same employer in another country. There is a certain amount of time that is allowed and is permitted for being on assignment. However, if you leave that employer, then you have to apply for a fresh skilled worker visa. But going abroad and coming back for the same employer is permitted. So that's fine. For those who may currently be sponsored for a role that was previously on the occupation, the visa still remains valid, correct? If so, what happens if you need to renew the sponsorship for an additional 2 years when the current visa is due to expire? You may currently be sponsored for a role that was no, so that will continue under transitional arrangements. So if you're already on a occupation that's on the list already and you extend, that will just continue because you're already in the UK. So that's not an issue. And then we have, what can we do if there are employees for whom we have done right to work checks after their first day? Any way to rectify the situation and not be fined in case of an audit? Well, like I say, the Home Office is not a witch hunt. You have to have a reasonable explanation as to why it was carried out afterwards. And if you keep a record of that and your records are good, then I can't see any reason why the Home Office would instantly do any fines, because the objective is not just to issue fines because of a breach. There has to be a serious reason for a breach. there. I don't know if there are any more questions, but yes, there are. Sorry. So for business visitors, how would the Home Office know if the person is working in the UK under the 6-month visa? So I think I did actually touch on this. This is one that is an interesting one. We will wait to find out. It is a grey area. And I think we're going to wait and see what happens with the stakeholder groups and when the consultation process starts, because once this takes effect, we will see how this works. But there are guidelines and advice that I would give around it to help companies manage business visitors, but we can talk about that offline. But yeah, any other questions, please do feel free to ask, and I hope I've answered as many as I possibly could. But again, I really appreciate that you're all here. I've just gone over time. And again, thank you all very much and look forward to seeing you at the next one. Take care.